All right, everybody. Again, thank you for joining me for our Ask Brian Q&A today, where we come in, answer some questions, hopefully give some guidance, some direction. It's why we do these webinars on Wednesdays. It's why we like to share at different presentations and seminars, because there's a lot of misinformation out there and there are a lot of questions out there. So this forum is a place for you, if you're new to us, where you can get to learn how we handle things and get to know us a little bit better, and perhaps we can help you with your specific planning or protection or care needs. Okay, before we get started though, just a little bit of housekeeping. First and foremost, this is an educational presentation. It is not specific legal advice to those that are asking these questions. My answers will be general in nature and they can't be exactly specific, giving you concrete answers and direction. By you attending this webinar, we are not creating an attorney-client relationship. However, if you are a client of the firm, please know that there's no confidentiality here. All right, this is an open forum, it's public, so there's no attorney-client confidentiality for any questions or answers given during this type of a webinar. If you do need, however, specific legal advice, we do offer with myself free Zoom consultations as well as in-person consultations here in Melville. We are an elder care law firm, and what that means is we spend a tremendous amount of time helping our clients get the best care possible. But before those care needs arise, we do all of the planning that's necessary and all of the protection that's necessary so that we can enjoy those golden years and really strive for that peace of mind. All right, so let's get into our questions. If you do have any questions that come up as we're going here, feel free to add them into the chat box or into the Q&A. All right, so before I get started into the questions, just please, into the chat box or Q&A, just let me know that you can hear me and see me. Please just let me know you can hear me and see me, and then I know we're good. I know there's a bunch of you out there. Come on, somebody type it in there that you can hear me and see me. There we go. Good, thank you. All right, so our questions for today. Let's see where we are. I gotta minimize my screen here. Hold on a second. All right, so here's our questions. Now, the first question deals with what's called a revocable trust, okay? So we have a question from Angela that is asking, does a revocable trust include, or can a revocable trust include some type of beneficiary protection for those that will be inheriting after the client passes on? And real general, a revocable trust is one of the tools that we use all the time as far as helping our clients plan their estates. It is the probate avoidance tool of choice. The idea of probate is that when a client ultimately does pass on with assets that are owned by them individually or solely, meaning not joint, not with a beneficiary, and not owned by a trust, then that family has to endure the probate process, which means they have to engage a firm like ours and have the will determined to be valid. That's what probate is. And probate should be avoided because of the amount of time it takes, about 6 to 8 months to complete, assuming everything goes smooth. There's court filing fees, there's lawyer fees, and most of all, probate is a public proceeding. So the petition, which contains assets and children's names and addresses, are all out there in public. And it's something that should be avoided, especially in this day and age with identity theft and fraud and so forth. So one of the ways that we help our clients avoid probate is with what's called a revocable trust. In fact, a revocable trust is the tool that's utilized to avoid probate. Contrasting that with what's called an irrevocable trust. The irrevocable trust, while it is a trust, and yes, it avoids probate, the irrevocable trust, which I'll be talking about a little bit more in another question, is all about asset protection. So irrevocable equals asset protection, revocable equals probate avoidance. Now, the question here specifically from Angela is, can a revocable trust include a beneficiary protection trust? So this is dealing with inheritances. And an inheritance, as most of us realize, is what people inherit from us once we're deceased. There are two ways that an inheritance can occur. It can be an outright inheritance, meaning your will or your trust says, when I decease, then X 50%, for example, goes to my son, 50% goes to my daughter, outright. That means a check is written from the trustee or the executor. The funds are transferred over once as the estate and trust are closed, but it's outright. There's no strings attached. There's no control. There's no gatekeeper. That means once those children get those funds, they could do whatever they want with those funds. They can down payment on a house. That's good. Down payment on a business. That's good. A wedding, if they've been saving up for it, that's good. Overspending, addictions, losing it in a divorce, misuse, being taken advantage of by friends and family because you have a lump sum of money, those are all bad. And when a beneficiary inherits outright, it can go either way. So what a lot of our clients do is they try to protect against that misuse of an inheritance. And I basically call it the D's, all right? The letter D. So if you have a child, perhaps they're going through a divorce, perhaps they're disabled, or they have debt issues, or they pass away, they die, right? Or the last D is they just do something dumb with the money. We always have to be mindful of how inheritances are going to land and hit our loved ones. So the alternative to those risks is having the inheritance held in further trust until the beneficiary is older, or until certain events happen, or even for the balance of their lifetime. So when I see the phrase a beneficiary protection trust, there's different types of trusts that can shelter an inheritance for a beneficiary. The first one that comes to mind is what's called a supplemental needs trust. That is a beneficiary trust that can be built within your revocable trust or within your will, and that would shelter an inheritance if a beneficiary was disabled and perhaps on SSI or Medicaid themselves. All right, that's the first type of beneficiary trust. The next one is more of a discretionary trust. Okay, now there's different types of discretionary trusts, but again, the supplemental needs trust is one where the money can only be used for purchases and expenses that the government programs are not paying for. Okay. Now, the discretionary trust is for one that is not on government benefits. It's for one where you need a gatekeeper, where you need another set of mature, experienced eyes to be in charge of the distributions and the purchases. So there's two types of discretion. There is what we call an ascertainable standard, which means I can leave assets for my kids in trust until, let's say, they're 30 years of age, or again, it can go lifetime. But the standard of distribution is that if the request from the child is for a distribution for health needs, education needs, or what's called maintenance and support. So HEMS, those four distribution levels are the ones that the trustee is supposed to say, okay, this is a doctor bill, I'll pay it. This is a tuition bill, I'll pay it. This is for a legitimate down payment on a house, I'll pay it. So it gives the trustee the discretion within those four categories to say yes or no, all right? The other type of discretion is really an unfettered discretion where the trustee has full 100% authority to decide on any and all distributions. This actually provides more protection for the beneficiary. To answer your question, Angela, the answer is yes. A revocable trust can contain a trust that protects the beneficiary. So can an irrevocable trust, and so can a will. But again, as I said in the very beginning, we really don't want the will controlling anything because we want to avoid the will. We want to avoid probate. We'll talk about wills again in another minute. Now, the next question, the question is, I have retirement accounts and bank accounts with beneficiaries. I'm thinking of setting up a trust to own my house, but I'm looking to take care of my grandchildren, not my children. So in essence, the ultimate inheritance is to skip the children's level and drop down to the grandkids. And yes, that can actually be done. So it would be similarly, as I was just answering to Angela, if the children are not going to be beneficiaries, you do want that documented as to why in the attorney's file, just in case there's challenges down the road. But you can certainly have the inheritance skip that child generation and go to the grandkids in trust. Okay, so you're going to want a discretionary trust there, and possibly, depending on the health and the needs of the grandchildren, perhaps a supplemental needs trust, which again is for those that may be disabled or on government benefits. All of our planning documents, our wills and trusts, include that supplemental needs trust as a contingency, because we can create a will or a plan, a trust today in 2021, but we don't know if somebody's going to be disabled and on government benefits in 10 years. So we always build that type of a supplemental needs trust in as a contingency. Secondly, we build in a contingency, a discretionary trust on contingency based on age. All right. Typically 25 years of age is when a grandchild could inherit. But again, depending on the amount of the money and the needs of the family, you may want to go older, or you may even want to have it extend for the lifetime. And then you have a decision to make as to whether it's going to be that discretionary trust with the ascertainable standard of health, education, maintenance, and support for the grandchild, or whether it's going to be that full discretion within the trustee. All right, so hopefully it can be done, and hopefully that answers your question. Changing gears, Diane is asking, in essence, she's asking who would be an ideal client for the services that we offer. The question is, how much in assets does a person need in order to become a client? And I'm going to say there's no dollar figure, there's no maximum, there's no minimum. We do help with planning at all levels. If there is a high net worth client, then I may bring in colleagues of mine that I've been working with for years, because then you're dealing more with tax planning. But we certainly work with those types of clients. But on the lower end, we've done plans for folks that have $50,000 to their name, have $500,000 to their name, have $5 million to their name. Different types of planning, though. So generally speaking, an estate plan is appropriate for an individual or a couple that have certain assets. Now, when people think of estate plan, they often say, oh, it's a will, I need a will. But the reality is the will is just one part of an estate plan, because the will only kicks in after you pass away. And there's a lot that can happen between 2021 and that time frame. So a basic plan is going to be your last will and testament, a durable modified power of attorney, a healthcare proxy, and a living will. Those four documents, probably the power of attorney being the most important, are the foundation plan, the essential plan for anybody, regardless of age, regardless of health. We had a consultation in the office here with a colleague of mine and a couple. They're worth over $25 million. Guess what? We spoke about those four basic documents. Now we're going to layer on and add in other tax saving and trust vehicles for their strategies. But those four basic essential documents are necessary for every adult, regardless of age and regardless of health. Then when we meet with clients that are 65 years of age and older, we start talking about what we call an elder care protection plan. That will bring in the irrevocable trust and the preparing for care down the road. Okay, so, and I'll get into that a little bit. I think one of the other questions talks about that. So that's 65 and above. Now, is that for everybody? No, it's not. Generally, a client that has a home, if there's a piece of real estate that is owned, an irrevocable asset protection trust is a great flexible tool for that individual. If it's a co-op in the city, it should be protected, but because it's a co-op, and it applies to co-ops out here also, but the co-op controls what can be done with those shares of stock. Can they be protected in an irrevocable trust? That's a question for the co-op board. But if it's a condo, if it's a townhouse, if it's a freestanding building, a home, then 100% you have a deed to that property, and you should be protecting that home in what's called an irrevocable trust. If there is no real estate or co-op, then it comes down to the amount of liquid assets that a person has. If I'd say if there's $100,000 or less, you need a plan, but maybe you're not setting up a trust. Maybe if we have children that we can talk to, all right, the required complexity of a trust can certainly be utilized with a $100,000 estate, but the greater the assets, the greater the need for flexibility and control, and that's where the trust comes into play. All right, so hopefully that answers your question. Next question from Cindy. Now, so Cindy, I looked at this earlier, and I've been doing elder care work and elder law work and planning work for nearly 24 years, and I wish I had a better answer for you. The question is, can I talk about long-term care through Medicare? Medicare, unfortunately, does not provide long-term care services. What does, however, is Medicaid, all right? If you've ever been through a consultation with me, you'll hear me share that there are different things that can happen to us, right? We can have something that is medical in nature, such as requiring a doctor or a hospital or a rehabilitation center where we can receive physical therapy, occupational therapy. So doctors, hospitals, therapy services, those are all medical needs. Those are medical services. You're welcome. And what you're looking at is them being covered by Medicare, okay? However, on the other hand, what people can endure and face are those needs that are not medical in nature at all. You may just need help walking, bathing, toileting, very, very serious personal needs, but they're not medical in nature. They're what's called custodial or chronic, what we call long-term care. So medical needs, doctors and hospitals are covered by Medicare for the most part. And then long-term care needs are covered by Medicaid as long as the person is eligible. Medicaid is a very complicated and getting more complicated as the days go by program that can pay for your home care and can pay for nursing home care. So what you're looking at is how do you become eligible for Medicaid? And I have been doing, if you've ever been to our website, tullyelderlaw.com, Tully, elderlaw.com, under our videos tab, you'll see a link for webinars. I've been doing webinars weekly, some monthly in the very beginning, but mostly weekly for the last several months, all about asset protection trusts, about planning, about Medicaid and the changes that are happening. So this little commercial, if you will, is to say, if you want a little more depth on the Medicaid at this point, go to our webinars, our webinar tab. And just last week, I did a webinar on the changes that are happening in the home care world on the care side, okay? So Medicaid is out there to pay for the long-term care. Medicare is out there to pay for the medical needs. Okay, so hopefully that does answer your question. But I saw, Cindy, you were asking some questions in between. So let me see. Okay, so perhaps what you're referring to, Cindy, is rehabilitation services. It's not going to be when somebody, there's two little buts when we talk about Medicare and long-term care. When somebody needs rehabilitation services, as I was mentioning earlier, Medicare is in fact paying for those services, and it's within a nursing home facility. Okay, so most nursing home buildings are broken into two parts: the rehab and the long-term care. The rehab being medical, the long-term care being private payment or long-term care insurance or Medicaid. Nursing homes, the long-term care portion can be anywhere from $14,000 to $20,000 a month. Okay, very, very expensive. So most folks end up with Medicaid. Now, the rehab portion, that is a Medicare benefit that's triggered when there is a 3-day, 3-night qualifying stay within a hospital. That means if you've been admitted to that hospital, not just in the hallway, but actually admitted, which is a whole nother conversation, for the 3 days, 3 nights, then you can be transferred to a rehabilitation center and receive up to a maximum of 100 days of rehab, physical therapy, speech therapy, occupational therapy, etc. Medicare will in fact pay the first 20 days in full. And if still qualified, then Medicare will continue to pay up to 100 days maximum. After day 20, there is a daily copayment of about $185 a day, about $5,000 a month from day 21 through day 100. If you happen to have what's called a Medicare supplemental policy, then that has the right powers, the right benefits, then that copayment will be paid for by that supplemental company, which again is a good segue. In 2 weeks, we have Doreen Marino joining us. She is a Medicare specialist. So check our website and wait for our emails and register for that Medicare conversation in 2 weeks. But the bottom line there is that rehab stay will end either at day 100, which is rare, or it may end at day 20, or it may end at day 25 or day 40. And then you either go home for more care on your own or Medicaid, hopefully, or go long-term care at that point, all right, within the nursing home. Now, Medicare can also cover what are called CHA services. Those are certified home health aides. That happens for, it's also called intermittent care, and that's going to be for a 4 to 6 week period after discharge from a hospital or after discharge from a rehab center. So Medicare will do that, but it's really not long-term in nature. It's short-term, it's intermittent care, okay? So hopefully that clarifies things for you. Next question, Walter. How can an irrevocable trust where somebody else is the trustee guarantee continued income from my spouse and I from pension, Social Security, or other sources while protecting the assets? Good question, Walter. I'm glad you asked it. So a couple of points. The irrevocable trust, and again, if you go to our website, we talk about the irrevocable trust and the Medicaid stuff a lot on the different webinars that we've done. The irrevocable trust is hands down the most flexible, secure way to shelter assets when we are planning in advance or in a crisis in some circumstances for long-term care. One of the biggest rule, there's two big rules when it comes to these asset protection trusts. And the first one is that you're going to have a look-back period to contend with. You know, if you set up an irrevocable trust in 2021, you have a 5-year look back. I know it's confusing. It says look back, but you really got to look ahead for the next 5 years. And that 5-year look back applies to nursing home care. So that's why I mentioned earlier, we want to do our elder care protection plans for everybody at 65 and over, because we don't know what tomorrow holds. We don't know, none of us have that crystal ball, if you will. So the sooner you can get the planning and protection done, the sooner the clock starts to run, the sooner the clock ends, all right? Now, the other big rule with the irrevocable trust is what we call the no principal rule. Whatever is inside that trust must be off limits to the parent, the grantor creating that trust, all right? So Walter, if you set up this trust, you have to realize whatever's in that trust is going to be protected. And in order for it to be protected, you do not have the ability to withdraw money directly. And the trustee does not have the ability to write a check to you directly. Directly being the catch. There are ways for the funds to be distributed to children, etc. But the concept is, in order for those assets in the trust to be protected, we build a wall around them, okay? It's all about access. And if you have access to the principal inside the trust, then so does your creditor, then so does Medicaid. So we have to cut that off. Otherwise, you live in that house for the rest of your life. You have the ability to sell it. You can control the trustees. You can control and modify your beneficiaries if you'd like. Taxes all remain the same. It's quite astounding the amount of flexibility and benefits you get while protecting the assets inside. Now, to Walter's specific question, income. If you have a house sitting in there, generally there's no income. But if you put a rental property in there, then you might have a net rent that's distributable income. If you have an investment account gaining interest and dividends, that is income. This type of trust, it's what's called a grantor trust, Grantor. And what that means is all of the income tax consequences flow through the trust back to the grantor. mom, dad, husband, wife, whoever that may be, you're paying the taxes on it. Now, that income, while it's sitting in that trust and accruing, it can get distributed back to mom and dad, husband and wife. It can stay in the trust, or it can be distributed to the children. Now, again, your specific question, Walter, is asking about pension and Social Security. What's good to realize here is those income streams never, ever go into the trust. Okay, so if you have a house and let's say a $200,000 investment account and a $10,000 checking account, all right, that $10,000 checking account is probably where your pension goes, where your Social Security goes. That stays outside of the trust. So that income is not a part of the trust. The trustee has no say. The trustee has no control. The trust doesn't even talk about that kind of income because it's always in your personal account, not the trust. I hope that makes sense, Walter. The income we talk about in relation to a trust is just the income generated off of the investments inside it. All right. So it's the interest and dividends if you put that $200,000 in there. That's where it can be distributed to you. Okay. So hopefully, Walter, that answers your question. Next, Marvin. Next question. My estate is slightly over the New York State estate tax maximum limit. How do I avoid having to pay this New York estate tax? Big topic, just like all these. So I'm going to try to answer it in a couple of minutes. An estate tax is one where the government will tax your assets, your estate value, if it's over a certain threshold. All right. If a person passes away and they are over the threshold, they're going to pay a New York estate tax and possibly a federal estate tax. All right. If they're under the threshold, then no estate tax consequences at all. The good news is the estate tax thresholds have grown dramatically over the last 10 plus years. They were for decades, they were always under $1 million. And gratefully, they start to grow. Now, in New York, we have a 5.9, let's say $6 million estate tax threshold in New York. And what that means is every dollar under the 593 that is under that will not be taxed whatsoever. However, if you go over the 5.9 number, then you're going to start getting hit with New York estate taxes. Okay. Now, what's unfortunate about the New York estate tax situation is they gratefully increased it to this 5.9 number, but the state did, but they added what's called a cliff. And what New York did was they said, we'll give you X amount of dollars, no New York estate tax whatsoever. But if you go 5% over the 5.9, which if you do the math, will put us about 6.2 million, right? 10% of 600,000 is 6 million is 600,000. 5% is 300,000. So if you go from 5.9 to 6.2, you're incurring some tax because you're over the 5.9 and you're still under the 5% cap. But as soon as you go 5% over, you lose the entire estate tax exemption for New York State. So if you have a $6.3 million estate, every dollar from $1 is going to be taxed by New York State. So what clients are doing, and it depends if you're married or not, because there's different estate tax allowances, if you will. If there is a spouse involved, then what we do just reflexively is we build in what we call a credit shelter trust. That's the foundational marital estate tax trust strategy, where each spouse will have credit shelter trusts built within their will and trust. And that way they can use their exemptions. If we have a $6 million estate, each of them would have 3. That way we're not doubled and over the 6, okay? That's, again, it's a reflex. That's what you do. When you have that kind of money with a spousal situation, the credit shelter trusts are the way to go. If you do not have a spouse, however, there's gifting that can be done. There's spending that can be done. Gifts can be made to children, to grandchildren. It kind of gets into gift taxes, which is on the federal side. There is a $15,000 per person per year annual gift tax exclusion. So you can give each of those 15 or each of those family members $15,000 each, reducing your gross estate, your taxable estate perhaps. Bear in mind, however, that New York has a 3-year clawback. So if you're at $7 million today, you give away $2 million tomorrow, you are now at a $5 million estate, but you pass away in 2022. You're under that $6 million, so no estate tax, right? It's not how it works, because they'll go back 3 years and bring it back in and then tax everything. So again, it has to be a part of a plan, Marvin. There are things to do. There are even ways, strategies in which you can leave a certain amount to charity, leave the amount over the 5.9 or the 6.2 to a charity. Therefore, it's not taxed. Again, different strategies that can be done. All right. Now, hopefully that answers your question, Marvin. Next question. Dominic, my house is titled to an irrevocable trust with a life estate for me. My 3 sons are the trustees. That's a lot. We like 1 or 2 trustees, so hopefully it's all working out smoothly for you. Your wife did pass a number of years ago. I'm sorry to hear that, Dominic. I do have transfer on death or pay on death savings accounts with beneficiaries. My IRA has beneficiaries. Do I still need a will? So to sum that up, you have a trust, you have accounts with beneficiaries. Do you still need a will? First question that comes at me. If you have an irrevocable trust with the intent of protecting your assets from long-term care, Medicaid, then the assets that are left in your name without IRAs, okay, without I'm sorry, something happened to my screen. I got distracted there. The money left in your name that is non-IRA money, that is still susceptible to Medicaid, okay? So if you've set up an irrevocable asset protection trust for your house, perhaps consider transferring or protecting other monies. You do not have to protect IRA money. There's a lot of caveats with that as far as age and payout status. But if you have other monies in your name, again, they're not protected. Now, to answer the question, do you still need a will? I'm going to say yes, you do. The goal, however, is to not use it, as I shared in the first couple of questions. A will requires probate, and you want to avoid probate because of the time, because of the cost, and because of the lack of privacy. And the way you do it is really what you've got written here, Dom. You've got your trust, you've got beneficiaries on your accounts. You could also have trustees on your accounts. That way, joint owners on your accounts. That way, you're not going to have to go through probate. But my solid recommendation is going to be you still have a will just in case. There have been numerous times where a bank or financial institution loses the transfer on death, loses the beneficiary form. And then what? Then it gets payable to your estate. So you want a will there just in case. In addition, you want a will as a default. If you do forget to change one of your beneficiaries, or God forbid a beneficiary dies and you don't update it, you want that will to direct the property just in case. All right. So yes, you're going to want a will for a whole host of potential risks, but you still don't want to use it. All right. Last question I have here is from Debbie. How do you get your loved one who has more than $15,000 in their savings account onto Community Medicaid? What can you use their money on? How can they spend it? Okay. Now, the good news, Debbie, is, and again, webinars on tullyelderlaw.com get into the depth, but I'll give you the overview here. We have 2 Medicaid programs in New York. We have nursing home Medicaid with the 5-year look back. The purpose of the look back is for Medicaid to find any gifts or any asset protection steps and then penalize them so they do not have to pay for the care for a period of time. That's nursing home care for now. Home care, which is Community Medicaid, for now, does not have a look back period. So what that means is if you have a client or a loved one with $100,000 in their name and a house, and they need Medicaid for home care, those assets can be protected. And as long as the application is filed before the law changes, which I'll talk about in a moment, then there will be no look back period and no penalties. And the assets that were transferred and protected should be that way for the balance of your loved one's life. So again, Community Medicaid does not have a look back. That's changing though, all right? Sometime soon. This is probably the number one topic we've spoken about the most over the last 12, 16 months. The governor in 2020 signed a new law creating a look back period for home care. Never existed before. I've been doing this almost 24 years, and we've never had a look back period for home care. So the creation of a look back period was last year. However, it has not yet been implemented because of the pandemic. So the look back for home care in New York is not yet in effect. It was supposed to start in 20, it didn't. It was supposed to start this year, and it didn't. Was supposed to start January 1st of 2022. That's still the technical start time for the look back, meaning all applications before January 1st, no look back. All applications after the law is implemented, perhaps January 1st, will have a look back, which means penalties and waiting periods, just like the nursing home. But about 2 weeks ago, there have been some rumblings and some rumors that they may be postponing the implementation of the look back period till either April 1st of 22 or July 1st of 22. As we get more confirmations, we'll let our people know. If you're on this webinar, you've gotten emails from us. So we'll be doing more webinars and talking about the changes. If you happen to join me last week, this new law I'm talking about has two parts. This look back is one of them. Care changes is the other part. Now, those regulations are actually coming into play. Next month, November 8th, is when the home care changes are supposed to roll out. Now, the good news is they're saying, New York State is saying they're not all going to roll out on November 8th. New York State has to kind of line up and prioritize what they're going to change first on the care side. In the meanwhile, it's not happening. All applications remain as complicated and as difficult as they are until the new changes are effective, which we don't have an exact date just yet. All right, so Deb, to answer your question, you can spend the money, you can transfer the money, you can set it into what we call a slush fund just to kind of hold the money to pay for mom's care in the interim. Bear in mind, a Medicaid application takes anywhere from 4 to 6 months. Okay, so you always want some money left over. You do not want to spend all of mom's money and then apply for Medicaid, because you're going to have several months in which you're going to need to keep the house afloat and pay for care privately in that time frame. All right, so those are the questions that I have. As always, it's a great pleasure talking to you and doing these webinars and sharing this information. You're welcome. Let me just check the questions and see if we have anything else here that I can answer. Can I elaborate on what durable means for a power of attorney and what type of modifications? Great questions, Mr. Clifton. What we're looking at is a power of attorney is where you can appoint somebody to handle your legal and financial matters. Very, very crucial document in case there is a decline in mental capacity down the road. If there is a decline in mental capacity down the road and there is no durable modified power of attorney in place, then the family is going to be forced into a guardianship proceeding. Worse than probate. You're talking 6, 8, 10 months, a declaration of incapacity by the court, thousands and thousands of dollars in legal fees. You don't want a guardianship proceeding. It can be avoided as long as we still have mental capacity and as long as the power of attorney has the right language in it. So when I say durable and modified, durable is a very common term when it comes to powers of attorney. Durable means that the power of attorney remains valid, the delegation of authority remains valid, even if the principal, the one that signed it, loses capacity, okay? A non-durable power of attorney is void once the principal loses capacity, all right? The ancient, if you will, concept is that if I appoint an agent to do things for me and I lose capacity, that person can no longer do things for me because I can't do it, so they can't do it. The durable component became very important, and it's the only type of power of attorney we do because it says, especially in our world of elder care, that if I age and I lose capacity, that person can still help me and still take care of the affair. So durable is a requirement. In my world, modifications are also a requirement. New York State has changed the power of attorney several times over the last 11 years. And they just changed it again in July of this year, July of 2021. Now, in essence, the statutory form that New York State puts out there in the statute is the base form. It allows for modifications. They always have. When I started practicing in 98, the statutory form was about 4 pages. We expanded it with modifications till 8 or 10 pages. When New York State released the last updated form in 2009, it was about 11 pages on its own. We had to expand it till about 20 pages. What is the expansion about? What are the modifications about? It's about aging. It's about elder care. It's about asset protection and income protection, retirement accounts, tax planning, trusts. That language is not necessarily in the statutory form. So we have to modify it to make sure it includes those powers in case your agent has to deal with those things later on. The sad reality is I'd say once a week I'm sitting with a client and they bring their own power of attorney in thinking they're done. They don't need one, but it's either not durable, which doesn't happen a lot, but more than likely it does not have the modifications. Okay. So going to a LegalZoom type of site, going to a real estate attorney or a criminal attorney or your son-in-law who's a financial guy, getting a power of attorney in that type of a scenario usually means it's not going to be sufficient in our world dealing with elder care and asset protection and income protection and Medicaid. All right. So hopefully, Clifton, that answers your question. Next question. Hello, Robert. How are you? Good. I'm done with the questions. Thank you very much. Great to, again, see you all again, so to speak. And again, join us next Wednesday. We're talking about asset protection. Please be sure to sign up for that. We'll get into a little more depth about the trusts. Okay. Thank you again. And if you need assistance with the planning, the protection, the advocacy work, that's what we do every day of the week, and be happy to help. All right. Take care, everybody. Bye-bye.